suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting joins you now, Melbourne solicitor, to answer all your legal queries. David Whiting, good morning.
Good morning, Ellie.
I should say there are some spots left. This is incredibly rare. You must all be off enjoying the sunshine for the brief moment that we have it. But if you do have a legal question, jump on now because there is room and David will answer it. David, I'm a little bit confused about, and this is definitely a question without notice to you, but this protest on the Tullamarine Freeway, trucks carrying passengers and they've been breaching the Chief Health Officer's directions. I'm trying to work out what direction that would be because can it be illegal to gather if you're in a truck or is it the carrying of the passenger?
The answer would be you're only allowed leave home for one of 5 approved reasons.
Right.
Now,
okay. So
let's assume that someone leaves home to jump in a truck to go to work. If you are working, you need to get an authorised worker certificate signed by your employer. So let's assume that, and it's a bit weird. I come to town once a week to pick up the mail and make sure that it goes to the right people. But I am required to fill out an authorised provider and authorised worker permit. So as the employer, I authorise myself to go to do certain things. But in order to do that, I need to fill out a particular form that you get off the government website and sign it in 2 capacities, and I carry it with me. And it's a requirement that you be able to produce that document to a authorised officer, which includes the Victoria Police, upon demand. So let's assume that I'm an authorised worker and I'm going to work and I pick you up on the way. If you don't have an authorised worker permit and your reason for leaving home is not one of the 5 approved reasons, then you're eligible to be given a fine.
Right. Okay. Well, that's pretty straightforward, I imagine. 1300 222. Sorry.
Is, but it builds on one of the calls from last week. Malcolm from Ballarat is a member of the Theatrical Society.
Oh, that's right. And he had to go and move his stuff.
Well, he lives in Ballarat, and the organisation that he's a member of stores their goods on a property that's in metropolitan Melbourne, and they want to move them. And the question would be, how do I go? And the answer is with extraordinary difficulty, and it's far more complex than a 5-minute answer, but we'll try. There needs to be somebody in charge who's conducting an authorised workspace with authorised workers and who has a COVID-safe plan. So it can't be a bunch of 10 or 15 or 3 volunteers who simply turn up and pack it and take it. It needs to be structured and it needs to comply with the requirements of the Chief Medical Officer. So if Malcolm is listening, and Malcolm has incredible patience, on the 24th of September, which was the public holiday, the government published an update to the Chief Medical Officer's directions. They run to 218 pages. And on page 15, there is a section called leaving premises or entering the restricted area to attend work or education. So, Malcolm, I wouldn't even try with a 10-minute explanation, but that's where you can start.
Okay, so that was an update to the previous restrictions, is that right?
The restrictions have a limited life. So they, and generally they don't last more than about 4 weeks. So every time that the regulations are changed, they are, as a matter of practice, generally republished, because you can see that we're changing the Chief Medical Officer's directions often a couple of times a week. So I think it's in everybody's interest that there be a single document that contains the current rules as opposed to let's look back through 30 government gazettes to find out which ones apply today.
And indeed, even if you Google, you often pick up the wrong one. You go through it and you realise, actually, I'm a week out of date.
Yes, so I can tell Malcolm that it's Special Gazette number 529. It was published on the 24th of September, and it is at gazette.vic.gov.au.
Excellent. Very good. I'm writing that down. Never know what else you might find there. 1300 222 774 is the number. Trish has joined us from Ashburton. Good morning, Trish.
Good morning. How are you?
Well, thank you. What would you like to ask David?
Hello, David.
Hi.
Hi. We have a 24-year-old son who sent over a car, a patrol, to South Australia to have it modified in August last year. So he sent it over to a mechanic, but he also paid him up front. He sent over $20,000. And now he's been communicating with the chap who hasn't finished it, he wants his truck back. He wants something, but he's hamstrung and doesn't know what to do with this guy. Legally, he hasn't signed any contract. He shipped the car over there himself. It's a big four-wheel drive, and he just wanted to have it modified. And now he's finding that he's without a truck. It's been 13 months later, and the chap says he's got no money. He doesn't have the ability to buy the truck from him, or he started it, but he hasn't finished it. So he doesn't know. He doesn't know what he can do. Do you have any advice?
Can he appoint someone over there to go and talk to the mechanic?
We don't know anybody over there, so we don't. Yes.
So what I just don't want your son to put good money after bad.
Exactly. So it is a bit of a life lesson for him, but yes.
Well, what gets me is a $20,000 modification to a patrol, but let's put that to one side. Trish, I would be, I suppose, is he prepared to take the vehicle back in its current condition and then have the argument?
He'd like it back. He's looking to move into state next year and needs to have the truck for work. That's provided we can get up to Queensland. But he's looking to move in February, and the car doesn't have an engine, so it's a rolling shell, he says. So it needs to be modified and what have you. He just wanted it back. If the chap couldn't do it, he wanted it back.
Trish, I would split this into two problems. The first is possession of the car, and the second is any financial adjustment.
Yep.
So I would be ringing the car carrying companies who will move vehicles like this. So you tell them that it's not capable of being driven, but it will fit on a flat top. It is capable of being brought back to Melbourne, and find out what that will cost and whether they can do it. And once you've worked out that that's a feasible option, then the issue is then the negotiation with the mechanic in Adelaide about, in fact, bringing it back, releasing the car and bringing it back. And when you've solved all of those issues, you can issue a claim at VCAT. There is a sufficient connection with Victoria for VCAT to have jurisdiction for any financial adjustment.
Okay. Now, the guy's being quite elusive and isn't answering text calls. He actually engaged a company to get the truck over there. So the transport company, he's done it one way. I'm sure he could do it another. So is he quite within his rights to just get the company to go and turn up and bring the truck back?
The answer is probably technically correct on the basis that he's paid and there's no money due to the repairer. But you're going to find that the the transport company that took the vehicle there won't want to go and fight for your son, but will be happy to go and pick it up. So your starting point has to be, I would like to have a representative at your premises next Thursday at 12 o'clock, and I want the vehicle available for removal.
And I suppose, David, the thing to do would be to send an email to that effect, that at this time there will be someone there. What do you do then if the place is shut?
then it's an action in South Australia, I think, for the handing over of the vehicle.
Trish, good luck. It is a complicated one. Paul in Warragul. Good morning, Paul.
Oh, hello. I've got a slightly different one. It's in regard to copyright. I'm a community radio broadcaster and I produce a small program, interview program for a local community station. And I'm considering trying to turn it into a podcast or some of it into a podcast. And one of the station personnel said they assume that the station has copyright of their programs. Now, I produce it unpaid on my own equipment at my own home. I do all of the research, all of the work on it.
But it's broadcast on the community station. David, is there a copyright issue?
Yeah, the copyright issue belongs to the station.
And why is that?
Give you. Well, think of this particular discussion that we're having now. The question is not who owns the conversation, but who owns the reproduction rights for the conversation. There's a delay of several seconds between what we say and what people hear. And as a result, it's the ABC which owns the sound files for this program. Now, in the same way, the community station that Paul's doing the work for owns the sound file. So if you think about it, Paul, let's say you write down some notes or a script and you speak to it. The answer is those words are yours, the words you say are yours, but someone else has made a recording of it and then sent it out to the world. The recording belongs to them.
So does that rule out a podcast?
No, it rules out a podcast without the consent of the community radio station.
So I've made the recording. I've just given it to them to broadcast.
Then I don't have a problem, provided that it's not. So if you were to package a program, for want of a better description, and provide it to the community broadcaster, and they then play the 59.5 minutes or whatever it happens to be, then the answer would be that's yours.
Well, there you go, Paul. Easy answer.
So but make it clear when you give it to them, you tell them that you're reserving reproduction rights.
Very good, Paul. Thank you for joining us. Caroline in Bayside. Hi, Caroline.
Oh, hi. Thanks for taking my call. I moved into a property that's got a native tree on the boundary, which is causing root damage to the neighbouring properties, which I obviously didn't know. Apparently the old owners have tried to apply to take it down and the council has knocked it back. But so my question is basically...
I take it, Caroline, that this is a significant tree under the Bayside local laws, is it?
I don't know if it's classed as a significant tree, but it's certainly, it's a native that needs a permit to be taken down. And basically, if it causes damage, do we need to, in future pay for their damage, whatever occurs? Or do the neighbours need to also do maintenance of the branches and the roots themselves on their side as well?
Caroline, they don't need to do anything.
Okay.
Right? And but I'm going to take that one on notice because it's something I've speculated about but never had to play with. And that is, who is responsible if you can't touch the tree?
Very good.
Right.
Homework for next week.
That's homework. Yep.
And David, can I ask you a question? If you've got a tree on a next door property that looks like it's in danger of falling, and if it did fall, it would fall onto your property, and you want the tree removed, do you have to pay for that tree to be removed?
No. Well, first of all, you can't. You have no right to move onto their property to cut the tree down. The next question is whether cutting it down is appropriate or whether it might just be trimmed. But what the law would expect you to do is, absent negotiation, is an application to a magistrate's court to restrain a nuisance. In a sense, to make sure that your neighbour puts in place arrangements that ensures the damage doesn't occur.
Right. Okay, Helen in Geelong. Good morning, Helen.
Hello.
Yes, Helen.
Hi. I've got a question around a will. My mother passed away last year, and I spoke to my sister last night, and she said that I wouldn't be receiving $30,000 less than my siblings, and I haven't received any of the documentation to say why I'm not getting as much as them. Even in the will it says an equal share. And it's regarding a loan I had with my father many years ago, and there was a loan contract, and it was all written up and through a lawyer, and then he lent me some money to buy a house. The house was sold, and then he closed it off and said, "Oh, don't worry, you don't have to pay it back. I don't want the money."
Helen, how long ago did you borrow the money?
It was back in 1990.
Right, so that's 30 years ago.
Yes.
Under the loan agreement that you signed, when was it to be repaid?
He didn't specify. And
if a loan agreement will say more than Helen acknowledges that she's borrowing $30,000 from me. It would normally include some requirement for repayment. It might be on the sale of the property or your death or whatever. And it might be that the agreement is no longer enforceable. So you've got a written agreement that says, Helen, you're required to pay me this amount of money. Sorry, you're acknowledging you're borrowing this amount of money, and I'm suggesting it will say, and it's repayable on, not a date, but the happening of an event. And if that event is more than 6 years old and it's a simple agreement, the loan might be unenforceable, and therefore you can't be compelled to pay it back. The question to me will be is whether the affidavit, the inventory of assets and liabilities included in the estate, show you as owing this is your mum's estate, but your dad's lent you the money?
Yeah, but my dad passed away.
When did your dad die?
In 98.
Yep. My view would be, without having seen the agreement, it's extraordinarily unlikely that they have an enforceable claim against you, that your mum or dad's estate has an enforceable claim for the loan repayment. It's really a question of how you want to provide for it. To me, depends upon the relationship between you and your siblings.
Oh, it's very tainted. I also spent about nearly $30,000 on my mum's house out of my pocket, and they're not acknowledging that either.
So, David, where does Helen go when you have a dispute like this?
Well, I would be getting some advice in relation to the loan agreement. The general proposition, Ali, is that it's a question of when is the loan repayable, and because that affects the enforcement period. The Statute of Limitations, the Limitations of Actions Act, says that your right to recover a debt expires, and it essentially expires 6 years from the date when it fell due for repayment. If it's a simple contract, but if it's a contract made under seal, where it's called the deed and says signed, sealed and delivered, then it's 15 years. But Dad died 22 years ago. So the question from Helen's point of view is Helen wants advice on the basis of the document that says it's not repayable. The document as to when it fell due for repayment.
Yeah, she needs some advice. Clearly, Helen, that's what I would be doing. Kevin in Mount Waverley, good morning.
Yes, good morning, Ali and David. I have an academic inquiry relative to trespass. On my block of land, how deep below ground and the airspace above ground do I own?
Infinity.
Oh.
Well, sorry, you can't go down below the centre of the earth because
you
then
don't
you'd be
own the
encroaching into
airspace,
someone
though.
else's.
Do you?
The answer is that your title doesn't have an upper limit or a lower limit.
So therefore, anyone...
But life is not that simple, Kevin, right? The courts will not allow you to enforce an unreasonable restriction. So if you're in Mount Waverley, the police helicopter will visit over you from time to time. The answer will be, I'm really very sorry, I'm not going to give you an injunction against VicPol preventing the police helicopter. So the issue will be you can't stop the planes, but in theory you own all the way up.
Very good, Kevin. Quite a simple question there in the end. Annie in Frankston. Hi, Annie.
Hi.
Yep. What did you want to say?
I had a contract with a builder for $50,000 to do some renovations. They basically charged me the $50,000 but never finished the renovations. And I've been to the builders through VCAT. I've been through the builders negotiation thing. Because
so that's the domestic building dispute centre, that one.
Yeah,
yep.
I've got that. I've got a clear certificate because he wouldn't turn up. I've only got his phone number and his business address. I went to the ASIC. I haven't got an address. I've only got his business name and an ABN, but I can't get an address anywhere. Have you got any advice?
The ultimate frustration of where privacy means no rights can be enforced. The ASIC database for business names in the name of an individual doesn't give you an address.
So where does that leave Annie?
Got to find him. She's got his name.
Right.
You'll have his name because the name of the owner of the business name will be shown on the documentation. But even that's a bit crazy because if it's the trustee for the XYZ Trust, that doesn't get you anywhere. His name's there.
His name's there. It's him, but of course he's not answering the phone or anything. He's probably changed his number. I just don't know where to go to get an address because I know if I go to take it on to VCAT or anything, I need an address.
Have you spoken to the Victorian Building Authority? Do they have an address for him as a builder?
Victorian Building Authority. No, I haven't done that.
No, he's got to be, as a domestic builder, he will be registered.
All right.
My expectation is that he'll be registered to an address.
Good luck, Annie, with finding that. One more very quick question, Mike, if you can be brief. Hi, Mike.
Good morning, David and Ali. Quick one. I purchased an online item of apparel some time ago. The organisation that offered to supply it didn't have it in stock. I asked for a refund. They credited it back to a voucher that I can no longer access. I said, please credit it back to my credit card. They refused to.
How long ago, Mike?
Within the last 35 days.
Then I would be disputing it with your credit card company.
Okay.
Unless there's an argument in the on-site, on the website for this company that says if we can't provide it, you agree to accept a voucher, which I think will be unlikely.
Mike, good luck with that and with your credit card company. Of course, we're all doing a bit of that online shopping at the moment, and I've got a text message from here from someone pointing out, we were talking earlier that apparently America thinks all our post offices are shut, and this texter Lou says in fact there is a significant international gateway facility where staff are self-isolating in Melbourne, and Lou says her daughter in Brooklyn was unable to post a parcel this week to Melbourne as her post office was directed not to accept postage to Victoria at this moment. So it's correct that parcels can't currently be posted from the USA. There you go. We might follow that one up as well. David, I hope you're not waiting for some important item to arrive from the US.
I can't tell you. There'd be client privacy. I can't tell you.
Love it. David, thank you so much. Lovely talking to you again. David Whiting there, Melbourne solicitor.